Okay, let's unpack this. Have you ever signed a contract thinking everything was, crystal clear, only to find out later that one tiny phrase could unravel the whole thing? Because that's exactly what we're diving into today. A truly fascinating legal deep dive. It's this contract dispute that went all the way to Zambia's Court of Appeal. We're looking at the case of Dangote Industries Zambia Limited versus ENFIN Limited. It's really a masterclass in how words on paper can be interpreted, challenged, and, well, ultimately decide fortunes.
Exactly. And our mission for this deep dive is really to pull out the most important nuggets of knowledge from this complex legal judgment. We want to help you understand how courts interpret agreements through the immense weight of specific wording and, the profound implications of what's not explicitly stated. As you'll see, a single phrase can truly make all the difference, especially, I think, when there's a disconnect between the process and the product in a service agreement.
Right. So let's introduce our two main players. On one side, we have Dango Industries Zambia Limited. They were the defendant in the lower court, the appellant in this appeal. And on the other side, ENFIN Limited. They were the plaintiff originally and the respondent in this appeal.
Okay, so the background starts back on November 10th, 2009. Dangote hired ENFIN through what was called a letter of mandate. ENFIN's job seemed pretty clear. Negotiate an investment promotion protection agreement, an IPPA, with the government of the Republic of Zambia, the GRZ. And they do this through the government's agent, the Zambia Development Agency, or ZDA.
Okay, and here's where it gets really interesting, right? The money. Clause 9 of this letter of mandate, it laid out the payment terms for ENFAN. There was a fixed fee, USD 55,000, excluding VAT, paid in two parts. 50% upfront for mobilization, the other 50% when they finished and submitted the draft IPPA. But then, and this is crucial, there was an additional flat fee of USD 70,000, again excluding VAT. And it was specified to be paid on successful conclusion of IPPA. That phrase, successful conclusion.
That's the key phrase. So following that clause, ENFIN issued an invoice for the first 50%, the mobilization fee.
Yeah.
That was $27,500 plus VAT. And Dango paid that initial amount, settled it on December 3, 2009. No problems there.
Okay, so fast forward about a year to December 9th, 2010. The ITPA itself gets approved by the government, the GRZ, and it's officially executed, signed, sealed. So ENFIN then sends a second invoice. This one included the remaining 50% of that first fee, plus that additional flat fee of $70,000 and, all the VAT.
Right. And here's the big problem. Dangote refused to pay the USD 70,000 flat fee, their argument. They basically said the IPPA only contains standard incentives, things everyone gets. It didn't include the additional fiscal incentives they were really after. They believed the $70,000 fee was only due if those specific extra fiscal incentives were actually achieved in the IPPA.
Okay. And ENFIN later sent another separate invoice just for the VAT part on the remaining mobilization fee, which Dangote also didn't fully pay. So things break down. ENFIN ends up suing Dangote for $85,600 plus interest and costs. They argued, look, we did our job. We got the IPPA signed. That was the deal.
Which brings us to the first court, the High Court. How did they see it? Well, the learned judge there really focused on whether ENFIN had performed its obligations under that letter of mandate, enough to be entitled to the flat fee.
Right. And how did they interpret that successful conclusion? Did they look at the context? I think you mentioned something about the ZDA Act.
Exactly. The judge looked closely at the context. Section 58 of the Zambia Development Agency Act. It says the Minister of Finance grants additional incentives, but based on recommendations from the ZDA. And the court noted, crucially, that this procedure was actually known to Dangote. They knew how this worked.
Okay, so Dangote knew the ZDA had to recommend things separately.
Yes, and what's fascinating here is the correspondence that came up. Before the IPPA was even signed, there was a letter from the ZDA dated November 17, 2010, and it explicitly told Dangote that the specific fiscal incentives they wanted could not be placed directly into the IPPA document itself.
Wow. Okay. So ZDA told them beforehand, these incentives won't be in the agreement you sign. And then just a couple of days before the signing, there was another letter, a letter of comfort.
That's right. December 7, 2010. ZDA sent this letter of comfort, assuring Dangote that they would be in a position to access those additional incentives later on, based on future ZDA recommendations.
So the High Court judge looked at all that and said
ENFIN had done its part. They'd negotiated for the incentives, even if the mechanism wasn't putting them in the IPPA. The judge believed the flat fee was payable simply upon conclusion of the IPPA. That happened December 9, 2010. In the judge's view, there was no condition written into the mandate saying the flat fee would only be paid when the fiscal incentives were actually awarded. Once the IPPA was signed, the ball was in ZDA's court to make recommendations.
Okay, so the High Court's thinking was IPPA signed, job done according to the mandate, pay the fee. They sided with ENFIN, awarded them the full $85,600.
Precisely. But Dangote wasn't happy with that at all. So they appealed to the Court of Appeal. They had three grounds, but let's focus on the core issues in grounds 2 and 3 first.
Right. So Dangote argued essentially that the lower court just misunderstood the letter of mandate. For Dangote, that phrase successful conclusion of IPPA in Clause 9 wasn't just about getting any IPPA signed. It meant ENFIN had to successfully negotiate and conclude an IPPA that actually achieved those specific fiscal incentives they listed back in Clause 3B of the mandate. Since only standard statutory incentives were in the final document, Dangote said, look, ENFIN failed. They didn't perform.
Exactly. They leaned heavily on that Clause 3B, which outlined the specific incentives. Dangote's lawyers cited legal principles, arguing that if one party fails to perform a promise that's a condition precedent, like they argued, securing these incentives, then the other party doesn't have to pay. They even pointed out that ENFIN's own witness, under cross-examination, admitted their duty was to negotiate for those special incentives.
And then there was that whole debate about the ZDA letters, the extrinsic evidence argument. That was Dangote's ground one, right?
Yes. Dangote argued the High Court shouldn't have relied on those ZDA letters because they came a year after the original mandate was signed to interpret the contract. Their point was the agreement was in writing, it was clear, and you shouldn't use later stuff, extrinsic evidence, to change or add to what the contract explicitly says. They cited a case, Holmes Limited, to back this up.
Okay, standard contract law principles stick to the written words. But how did ENFIN respond to that? They must have had a counter.
Oh, they countered strongly. ENFIN argued that courts, when interpreting a contract, are entitled to look at the intention of the parties. And you get that intention from the whole agreement and the surrounding circumstances. They cited several authorities, Anson's Law of Contract, some Zambian cases like Fine Chona, Friday Mwamba, basically saying you could look at the factual background, the genesis of the deal, to understand what the parties really meant.
So ENFIN was saying the rule against outside evidence isn't absolute. It can be used sometimes.
Exactly. They argued it could be used if the written contract wasn't actually meant to be the entire agreement, or if you need that outside evidence to figure out what the parties truly agreed on. But maybe their most powerful argument, connecting everything, was about variation by conduct. This is really interesting.
Variation by conduct. How did that work here?
ENFIN claimed that Dangote, by going ahead and signing the IPPA after they got those ZDA letters, the letters that explicitly said the additional incentives wouldn't be in the IPPA but could be applied for later. By signing anyway, Dangote effectively agreed to change or vary the original deal. Their actions, ENFIN argued, showed they accepted this new reality. They essentially waived the strict requirement, if there ever was one, for the incentives to be spelled out directly in the IPPA document itself. They proceeded knowing the situation.
Wow, okay. So signing the deal after getting that info meant they implicitly agreed to the change. That's a clever argument. So the Court of Appeal has all this. Dangote saying, you didn't deliver what was promised in Clause 3. ENFIN saying, we delivered the IPPA as agreed, and you accepted the process for incentives by signing. What did the Court of Appeal decide?
Well, first, they combined grounds 2 and 3, boiling them down to that one key question. Did ENFIN fully perform its mandate to earn the full payment? And they actually agreed with the lower court on one specific point. The payment of the flat fee itself was not conditional on ENFI actually securing the incentives being awarded. That's subtle but important. It wasn't a direct get incentives then get paid link for the fee.
Okay, so far sounds like ENFIN might win again. But I sense a however coming.
There's a big however. The court stressed that ENFIN was entitled to the full payment only upon carrying out the full scope of the mandate.
Ah, the full scope. Not just getting an IPPA signed, but fulfilling everything in the mandate.
Precisely. And this is where their focus on interpreting the contract as a whole became critical. They cited the legal principles. You figure out that parties expressed intention from the words they used in the document, read in the full context. What did they actually write down?
And when they looked at the whole document,
They went straight back to Clause 3 of the letter of mandate. The court said, it clearly sets out the fiscal incentives that the respondent ENFIN was engaged to secure. And Clause 2 explicitly stated Dangote wanted an IPPA specifically to outline fiscal incentives. The court felt the text was very clear about ENFIN's objective.
Okay, so the mandate did explicitly task ENFIN with securing those incentives.
Yes. And then came the crucial undisputed fact. It's not in dispute, the court said, that the respondent ENFIN failed to secure the fiscal incentives.
Ouch. So if the mandate said secure them and they didn't secure them.
Then they didn't fulfill the full scope. The court then tackled ENFIN's variation by conduct argument about the ZDA letters. They looked at those letters, but came to a different conclusion than ENFIN hoped. The court said those letters did not show a variation or change to the original mandate scope. Instead, the letters merely showed how those additional incentives would be obtained and at what stage. They clarified the process, but didn't remove ENFIN's underlying responsibility from the mandate.
So the letters explained the how, but didn't change the what ENFIN was supposed to achieve according to the contract.
That was exactly the court's view. The responsibility to negotiate for those additional incentives, as outlined in the mandate, still rested with ENFIN. Therefore, they concluded, Clause 9, the payment clause with the $70 K fee, was tied to the respondent, ENFIN, fully carrying out its obligations under Clause 3, the clause specifying the incentives. The clauses had to be read together.
So putting it all together, what was the final verdict?
The Court of Appeal found that because ENFIN failed to fully carry out the mandate specifically, failing to secure those additional fiscal incentives, as outlined in Clause 3 Dangote, was not required to pay the full amount, including that $70,000 flat fee.
Wow. So the appeal succeeded entirely.
Yes, the lower court's judgment was reversed. Costs were awarded to Dangote, a complete turnaround based on interpreting the full scope of the mandate.
We just saw how a seemingly straightforward contract clause, successful conclusion of IPPA, became this huge battleground. It all hinged on defining success within the specific agreed-upon scope of work.
Absolutely. This deep dive really hammers home the critical importance of, well, crystal clear language in any agreement. And it shows how courts meticulously examine every detail, the whole context, the overall intent. When parties disagree on what the words mean, it really underscores that what one party thinks success means or hopes it means might be very different from what's actually written down and legally enforceable. Was success the process or the product? Here, the court said the mandate demanded the product.
So reflecting on this, what really stands out to you about how courts navigate these disagreements, how they find the true meaning when the parties themselves see it so differently? And maybe think about this. How can just a small detail, or maybe what's not said explicitly, lead to such a massive financial swing, especially when, like here, a third party like the ZDA is involved in the overall process?